I'll also compress it and put it in a 3-page note, Milord.
You should not silence the judges.
No, Milord.
We are.
The lordships only hear the appellant,
Milord,
but lordship may wait
No, I
time.
want to again.
This is on the assumption
Is
that
it a matter where dispatch only should treat it?
No, urgent is the matter. Not
Milord,
necessarily this
Your Lordship,
urgent is the matter.
any sandwiching that will happen will happen.
My lord, may I
This
should understand our anxiety. Why we want this date?
My
lord, may I humbly suggest, my lord?
This arrangement is subject to 28 going on. If that gets adjourned,
Then today we can.
No, my lord,
That's not a-
may I humbly suggest one thing?
Here.
Our matter,
Those
Milord-
employees are suffering. Whether they get
Tomorrow
or
at
not
2
is another.
PM
We'll
also we
decide
can-
it once for all.
no, my lord,
Let's start
so
it.
far.
Ah.
That's correct. If so many councils are insisting, our matter can be taken up tomorrow at 2 p.m.
Because
Everybody.
pension they are not receiving.
No, that's. I am there tomorrow. Day after. I am at your disposal. No issue. If you want, I have come to argue. But so
We
many
can- We
councils.
can decide the disputes of the citizens, not disputes of the lawyers amongst themselves.
No, they must be representing some citizens.
Lord Switch matter.
Tomorrow, because you are saying. But that can go sometime because all this has been there since last 1 year. All of a sudden urgency has arisen in this.
Milord, I will do one thing. I'll do one thing. I'll try to compress my argument as much as possible and put everything in a note.
Your lordship now hear him only. Nobody else do this.
I'll do that tomorrow. I'll come with that note. I'll try to compress my argument as much as possible, Milord, so that your lordships have enough time.
Tomorrow. Huh?
29 and 30.
29 is, yes, 29 and.
This is 30 minutes.
29, Mr. Paliza may wait, we'll send words to you.
I'm waiting.
No, we'll send words to you,
Only
you need not wait here. We can't make you wait here. Yes, this employees matter will take up because of the day.
Grateful.
Yes, start, sir. How much time it will take? Any profound propositions are involved or ordinary service law jurisprudence?
No, proposition is also there. Lord, let me begin like this.
Yes. No.
No touch. Lord, let me just
Yes, sir.
highlight on the facts first.
Facts.
Lord, they are all employees of schools and colleges. They have come together because they are governed by the common set of rules. So therefore, the issue involved is common. So the principal contention, my lord, the writ appeal specifically which we have filed, that is whether the employees under the block grant, your lordship may kindly note this proposition, block grant.
How many types of grants?
Lord, I'll explain one by one. I'll explain. Whether they will be covered under the pensionary benefit rules, which is being extended to the fully aided employees under direct payment fold. Your system, your lordship may kindly also note this, direct payment system and block grant. These are two different connotations will not spelled out under the
Payment.
direct payment
Direct payment system
and block grant.
block grant. There are two criteria.
Lord, I'll explain the distinction and the scope and object of the rule and whether that rule by implication can be extended to such category of employees. That at the outset, let me start with the broad proposition that pension is a condition of service and that is subject to the rule. Without a rule, pensionary benefit cannot be granted to an employee.
Cannot be claimed by the employee, may be the correct answer.
Cannot be
granted.
claimed.
If state wants, it can grant.
That's correct. That is exactly what, my lord, is the point I have been canvassing, that it is under examination. We don't have to wait then, but let me begin on merit. So there is a set of rule, my lord, styled as Orissa Aided Educational Institutions Retirement Benefit Rules 1981. My lord, so far
I
this,
have one humorous question. Why in your state, the title of the act, title of the rules, they are so long, one furlong, they're longer than my quarters to the court.
I also ask the same question to myself very often, but yet to get the answer.
Yes.
So your lordship knows that certain people, they love to make the rule complex and but I'm not on that for the time being. Whatever is the rule, we have to go by that. So my lord, under the aided scheme, your lordship knows it is guided by earlier prior to 1969, there was no law. So far,
When the executive instructions were there,
yes. but
69 the Education Act came into force.
Education Act came into force. So, my lord, so far those private educational institutions are concerned, they were managed fully by these governing bodies or the managing committees. In case of schools, in case of colleges, we call it governing bodies. These are the two different connotations so far. The affairs of management of the educational institutions, school and colleges are concerned. So, my lord, they were establishing the institutions. For that, my lord, your lordship knows that the government permission, concurrence, recognition, so many concepts are there. So they are not necessary for the time being. I'll explain a little later. So, my lord, prior to 1974, that is for the first time, Act was enacted in 1969. The government decided to pay them grantee net. They are called grant in aid. So, my lord, it was in a proportionate manner. It was earlier 2/3 and 3/4, then full. Suppose, my lord, 100 rupees. The government will pay them 2/3. A rate means 2/3 of 100, 3/4 of 100. So this system was continuing, my lord, until 1983, my lord. 83 and 85, two different executive instructions were there. So they introduced the concept of 1/3 of the salary cost. Suppose it is 100 rupees. 1/3 would be borne by the state. 2/3 would be borne by the respective managements, managing committees or governing bodies, as the case may be. That is after completion of 5 years of service of an incumbent. Suppose somebody joined in 20, so in 25, he will be eligible for receiving 1/3 grant in it directly from the government. 7 years, it is 2/3. And after completion of 9 years from the date of initial appointment, that would be full deficit of the salary cost.
5
That
years,
means
7 years, 9 years.
9 years. So, but in case of institutions located in backward areas, that was 3, 5, and 7. This is 5, 7, and 9.
So years were there.
1/3, 2/3, the same proportion. But, my lord, the period is reduced to in case of
Any
women
such
education.
cases here? No.
No, my lord, I'm just explaining the concept.
The broad
What is
idea.
the broad concept? Whether individual cases are to be examined, your lordship, we have to look to the facts. I'm not on that. But what is the concept? So, my lord, this women educational institution also, they get in a graded manner of 3, 5, and 7 years for promotion of women education. So, my lord, the grant in it until 1994. So they were all regulated by the government executive instructions. They were not, Lord, we can
Is there
say,
any code, like granting aid code? in
no, there is
Karnataka?
no code. By simple
It's a compilation of orders.
compilation of executive instructions that came in 94. That's a statutory order. I'll come to that. So, my lord, in 94, because your lordship, there was mushrooming growth of educational. Earlier, my lord, there was one college in a block, 2 colleges were opened. So, like this, my lord, they subsequently applied for government permission. Then Government also granted it. Your lordship knows that once the demand is there from a locality, etc., for the spread of education. So the number of colleges and schools, they went off, these private educational institutions. So, my lord, your lordship knows the purse is limited. A seeker doesn't, my lord, permit any number of institutions to come up. So, my lord, from this 1/3, 2/3 and full salary cost after completion of 5, 7 and 9 years, they introduced, my lord, in 94, the granting an order in the same thing, but a particular cutoff date was prescribed, which came to be challenged. A new section was incorporated, section 7C, subsection 4.
Education Act.
In the education, your lordship may kindly have a glance at that. That is very important. That may be the guiding factor, because the state within the limits its economic capacity, my lord, has to bear this salary cost and other things.
136. Yes.
Page 136 of this book, if your lordship is holding his publication, Whaler book, my lord.
You.
I was told that the Honorable Court is having this publication. So there.
So judiciary and the executive are on the same page, same book. It is here.
That is why, my lord,
7C. Granting aid. This
Yes.
is with effect from
19, my lord,
1993.
7C4 was introduced in, my lord, 1 minute.
93.
The date, 94, the date, exact date.
14 of 19.
Act 14 of 1983. 93.
7C1 inserted, what is Act 14 of 93, date is not mentioned here. I think, my lord, that is in 94, my lord. 1694 was the date. So the exact date of notification, my lord, it is not in 1694. Where is it? My lord, anyway, this came into force from 94 because the granting aid order came into force. I'll show that. So this provision, my lord, was introduced by way of an amendment in Odisha Act 14 of 19. No, what is the effective date? What is the publication?
It regulates the granting aid.
Yes.
Let us-
It was not there earlier, my lord.
Ah.
So for the first time, it was given a statutory force. Earlier, they were all guided by executive instructions. So last being, my lord, published in 1985. I have come out with the executive instructions also. So the state government, my lord, before placing 7C, may I just show the 3 different granting aid orders which were there? Just show me. My lord, this is the first one, the decoupling. Secretary, assessor. This was the earlier, my lord, there was one department of education. Now there are 2 separate departments, higher education and school and mass education. It was schools and colleges, my lord, were under one administrative department, education and youth services department. So this common circular was guiding. Lord, your lordship may kindly look at the subject. The term, direct payment of salary to the teachers of aided non-government colleges, high schools and ME schools. I am directed to say that pending final decision regarding direct payment of full teachers' costs, this full salary, I was telling you, lordship, government have been pleased to decide to make immediate payment of full salary and 10% DA for the past 3 months, namely from March to May 1974, to the teachers serving in aided non-government colleges, high schools and ME schools which are receiving granting aid at full deficit 2/3 or 3/4 rate. I was telling you, lordship, it will exclude aided educational institutions under the control of local bodies, corporate bodies, and institutions run by the minority communities which will continue to receive granting aid under the existing granting aid rules. The director of
There are
public,
separate granting aid rules also.
which will continue to receive granting aid, existing granting aid rules, my lord, this 2/3, 3/4. Earlier, my lord, this 70 prior to 74.
Those rules.
Yes, those rules. The director of, in the case of non-government colleges, the inspector of school in case of non-government high schools, and district inspector of schools in case of non-government ME schools will be responsible for making the direct payment to the
ME
teachers.
schools means what?
Minor
Minor.
education, my lord.
Minor
Up to 7. Middle education. I'm sorry.
Primary, middle, yeah, middle.
Primary, middle, and higher, high school will be responsible for
So
making
director
the,
is responsible for
Yes.
making the payment.
for making the direct payment. The procedure will be as follows. My lord, these are the how the bill is to be prepared, etc. So this full salary cost earlier, my lord, in place of 2/3 and 3/4, my lord, from
100%.
74 till 83, they paid the full salary cost because the number of institutions were less. Maybe the budget permitted, they took this decision and continued to make payment until, my lord, 17/3/1983, my lord. Your lordship may kindly turn to the next resolution of the government. Direct payment of full salary cost to the staff of non-government colleges in the state maturing for grant. In continuation to GO number so-and-so dated 27/5/1978, I am directed to say that direct payment of full salary cost of the teaching and non-teaching staff of non-government colleges as admissible according to the prescribed yardsticks shall be payable to such colleges which have been accorded government concurrence prior to the academic session 1979-80. Millard, the colleges who have, Millard, they made two categories of colleges. Colleges, those who have got the government concurrence prior to 1979-80, Millard. Those category of colleges are not here. So they got the full salary cost, full deficit of the salary cost. The entire, suppose 100, they were paid 100 at the rate of 100. Until 1979 was the cutoff date they fixed. So with the government concurrence. But the colleges who have received government concurrence with effect from the academic session 1979-80 or thereafter, until further orders shall be governed by the new granting aid principle as detailed below. They are, Millard, this is the rate. Colleges in advanced areas will receive 1/3 of the deficit as granting aid after 5 years from the date of government concurrence or recognition, 2/3 after 7 years, and full deficit after 9 years. In backward areas, these periods will be 3, 5, and 7 years respectively. In the context, the criteria for determining an area, etc., how it is to be for the purpose of computing qualifying of 5 years for a college to receive granting aid, the date with effect from which the college has been accorded government concurrence shall be taken into account. So, a classification was made between two categories of colleges. Colleges with government concurrence up to 1979-80, they were put in one basket, full deficit of the salary cost, and colleges with government concurrence after the session 79-80, they would be governed as per the new principle. This, Millard, 3, 5, 7 years formally, they introduced.
Are these gazetted?
All these, Millard, they were getting salary, so they can't say.
No, I'm just.
Yes, they are gazetted, Millard.
Are they gazetted?
Yes, they're all, unless, Millard, they can't have that. They're gazetted, Millard. These are not in the issue now. I'm just explaining the background, how this direct payment system, granting aid, block grant, those nomenclatures, Millard, are to be understood while deciding this case because the whole crux is on that. So how do they put everyone in the same basket instead of a reasonable classification which has been made by the state that granting aid under direct payment system and block grant. So the retirement benefit rule, Millard, it does not extend to the block grant employees. But the court has said in one case earlier, which incidentally went.
Where is that idea of block grant?
I'm coming to that. No,
Nothing.
Your Lordship, no, let me just see,
This I have seen now.
Lordship got it?
Yes.
So these were the principles. The same thing has been reiterated again in 1985 September resolution. Then again in October 85, they reiterated this 1/3, 2/3 full deficit of the salary cost. Then Your Lordship may now come to 7C of the amended provision. So this was, my lord, from 85 to 94, my lord, during this decade. There are a large number of schools and colleges they came up in these states. So the state, my lord, faced accused financial burden because of this granting concept and all, which is primarily the responsibility of the private body which set off the institutions. But my lord, by effects of time, as a benevolent gesture, the government, on consideration, taking into account the economic capacity of the state, my lord, took this decision to introduce, which was also challenged and upheld, 7C. Virus was under challenged, that this discrimination and all, that has been upheld. I'll come to the decisions a little later. The state government shall, within the limits of its economic capacity, my lord, this is very important,
First decides.
first decides. And that too, my lord, the mode of, I'll explain how this mode of recruitment is also to be made in an aided college. It is not that any person as per the choice of the governing body would be appointed and state would be asked to bear the burden of the salary. I'm coming to that. There is a statutory rule to regulate the recruitment and other conditions of the service of the aided educational institution employees through a properly constituted recruitment board. The state government shall, within the limits of its economic capacity, set apart a sum of money annually for being given as granted to private educational institution in the states. No order according permission or approval or recognition under this act, whether prior to or after the commencement of the Orissa Education Amendment Act 1994, shall entitle any private educational institution to receive grant in it. That's it, market.
Yes.
So even if it is there, my lord, that would not ipso facto confer any right on a person to receive
No
grant.
legal entitlement.
No legal entitlement. Save has otherwise provided, no private educational institution which has not been recognized by the state government
It will not
under
get aid.
this shall be entitled to receive any aid from the government.
In other
Lord,
words,
aid, your lordship,
Taking the aid,
knows the very
recognition is a precondition.
Correct.
Ah,
So the very concept of aid, your lordship knows that, my lord, it is always dependent upon
Size of the purse.
yes, the
Correct.
ability to, my lord, pay. So, my lord, this is very important. C4 begins with a non-obstante clause. Notwithstanding anything contained in any law, rule, executive order, any judgment, decree, or order of any court, no grant in it shall be paid, and no payment towards salary cost or any other expense shall be made to any private educational institution or for any post or to any person employed in any such institution after the commencement of the Odisha Education Amendment Act 1994, except in accordance with an order or rule made under this act. Lord, 94 granting order came thereafter. It was, Lord, formulated in exercise of power under subsection 4 of section 7C of the act. I will place that. So, Lord, except granting it where admissible under the said rule or order, as the case may be, shall be payable from such date as may be specified in that rule or order, or from such date as may be determined by the state government. So So, my lord, absolutely it was left to the domain of the state to decide to what extent its purse permits and what would be the amount, etc., etc. And accordingly, my lord, in exercise of power under 7C4, which validity has also been upheld under challenge, the state makes different orders from time to time. The first order being in 1994, then in 2004, then in 2008, then in 2009. The last we are concerned up to 2009 now. All those employees are mostly under the 2004 block grant order, my lord. 94 is a grant-in-aid order. 2004 is a block grant order. So that is in exercise of power under 7C4. Similarly, your lordship may now provided that pending framing of such rule or issue of order, the state government may
Continue the grant, which was the case.
which was, my lord, immediately being paid. It's a saving clause. So, my lord, the grant-in-aid to be borne by state government on account of placement, my lord, we are not concerned. Up to this 4 is relevant. Now, my lord, in 94, the state government was pleased to come out with a grant-in-aid order styled as grant for schools and colleges at page, my lord, 545. 545. Yes,
94 grant in order.
it has been since repealed, but this was the first order under 7C4. Your lordship may kindly look at the preamble. In exercise of powers conferred by subsection 4 of section
These
7C.
orders have been issued.
Yes, the state government do hereby make the following order to regulate payment of grant-in-aid to private educational institutions or for any posts or to any person employed in such institutions being a non-government college, junior college or higher secondary school as specified hereunder. Namely, so and so similar, this order may be called Odisha non-government colleges, junior colleges, higher secondary schools, grant-in-aid order 94. Your lordship may kindly come to para. There are various categories of colleges in para 4 your lordship would find. Category 1, category 2, category 3. These are the different category of colleges. The grade is to be decided accordingly. Which category of colleges, etc. They have placed on basis of various factors like your lordship may now kindly turn to para 10 and 11. I think 10, 11 is 10. Your para 9 before that, let's see kindly. It is not automatic. The governing body's selection. In some cases, when a private college is established, the governing body or the management, I'll use the term management in respect of both school and college. They make their own selection, own recruitment without following the procedure. So on their own, they make the choice. After completion of a specified number of years of service, they submit the proposal to the government for approval of the appointment of those teaching or non-teaching staff. That approval is a precondition. Until and unless it is approved by the government, they can be. This is in case of purely unaided colleges. Once the college has been notified as an aided educational institution, the recruitment process, is to be conducted in consonance with the recruitment rules.
Normative.
No, recruitment rules of 1974.
Recruitment becomes normative.
Yes, normal. That's to a body called Service Selection Board. So I'll come to that. I'll show how those appointments, if we go to the genesis of it, are not as per the choice of the government recruitment body, nor the government is a party to this selection, nor pension was a condition of service when they were appointed by the respective private managements of those purely private colleges. So, my lord, until an employee, my lord, is, my lord, conscious that I am recruited, having been aware of a set of service rules which will guide his service conditions, pension being a condition of service, but he can't claim that I should also be guided by this particular rule. That's it. Am I clear, my lord,
Yes.
on this proposition? At the time of recruitment or entry into service, if an employee, suppose, my lord, is having a set of conditions of service, leave rules, pension rules, etc., so many, travel allowances rules, so many service conditions.
Yes.
So it should be at the time of entry into service that this rule was applicable to me. I was recruited with this conditions of service. Now I am being deprived of. So there may be a mandamus in that case. But the court, my lord, in my humble submission, my lord, cannot and should not. They should rather, there are two Supreme Court judgments recently, Odisha, Khadi Village Industries Board case and the UP case. I'll come to that. Unless, my lord, a pension rule is there, which is applicable to an incumbent, so, my lord, no pension can be granted. No pension can be. It's subject to, my lord, applicability of the rule. By implication, a rule cannot be made applicable to a set of employee, my lord, who by itself stand on a different footing, the nomenclature called block grant, unless it is specifically embodied in the rule governing the payment of pension. So it has to be, my lord, borne out from the language of the rule very clearly, categorically, and, my lord, understandably, it should be clear. By stretching the word that they are getting granted, so they should be treated as direct payment employees. It can't be like that. By necessary implication, my lord, we can't add any word or language to the statute or the lawmaker's intent and extend the benefit. That is, my lord, in a nutshell would be my legal submission little later. But let us first understand what is the background, how, my lord, those people have entered into service. The entry itself, my lord, otherwise, if we term it in strict sense of recruitment, obnoxious, in as much as merit was not the criteria, but as per the choice of a body of private persons, those people have got into service. So can they claim that the government is bound to pay us because we are already there? So that is what the concept, my lord, I will elucidate. So your lordship may kindly have this 9, my lord. A teaching or a non-teaching post in a non-government educational institution coming under category 1. My lord, this category I showed from para 4, that 1, 2, 3, etc. in respect of which granted has been sanctioned at any time prior to the
have been approved.
yes, approved post. So, my lord, what is the requirement for a post to be approved, my lord? That has been spelled out in the subsequent.
Other than one.
Other than one.
Other than one.
Yes. But the post in respect of which approval is sought is a post in an educational institution which has been notified as an aided educational institution. That is as per requirement of 3B of the Principal Act. A post in a non-government educational institution coming under category 1 for which no granting aid has been sanctioned prior to commencement of the Amendment Act, if the post was admissible as per workload and yardstick prevalent prior to the commencement of the amendment. There is a prescribed yardstick, that is, period wise. Suppose 25 periods, one teacher, then with 10 or 20%, there is a yardstick which was in 77, if I correctly remember, 8777 was a yardstick. Subsequently, so whatever, Milord, there is a yardstick. I am not going into what is the yardstick. That is not the concept. Say Mr. Swai and Mr. Rautrai They are very proficient in this law. I am a novice. So the little idea which I have to put forth.
Yes.
So a post in a non-government educational, Milord, I have finished it. The post was admissible as per the workload and yardstick prevalent prior to the commencement of the Amendment Act, has been filled up prior to that date. It has completed the qualifying period of 5 years or more, or 3 years or more in case of the institution situated in backward area. Milord, this because this was earlier 579, the same formula was repeated here. From 2004 onwards, this block grant concept came instead of this direct payment of 1/3, 2/3 and full in a graded manner of 5, 7 and 9 years. So your lordship may kindly have a glance at para 10. Granting it payable to an aided educational institution shall be the sum total of granting it admissible towards salary cost at rates specified below for each admissible and approved post from and after the date of eligibility, and granting it so payable shall be dispersed directly to the incumbent validly appointed and holding the post eligible for granting it, either by director or through any other agency so authorized by government. Government may from time to time determine the mode and form of disbursement. Milord, this is called, Milord, direct payment and employee gets. It goes to the, there is a mechanism, go to the government treasury. Bill is being prepared by the principal of the college or headmaster, who is the drawing disbursing authority designated by the prescribed authority, means director of the higher or secondary education, like that. It's a mechanism. I'll explain also how this block grant concept is being paid. Granting it for a post in a non-government educational institution coming under category 1 in respect of which granting aid has been sanctioned at any time prior to the commencement of the Amendment Act shall continue to be paid at the rate at which granting aid was admissible on the date of commencement of the Amendment Act, and such a post shall also be eligible to get granting aid at the rate of 2/3 of the approved salary cost 2 years after the date of receipt of grant at the rate of 1/3, and at the rate of full admissible salary cost 2 years thereafter, if not already paid at such rates. Not the same formula, 5, 7, 9 years formula was reiterated as was being adopted, followed till 1985. So now your lordship, the post in an aided educational institution coming under category 1 for which no granting aid has been sanctioned prior to the commencement of the Amendment Act shall be eligible to receive granting aid at the rate of 2/3 of the admissible salary cost from the date of eligibility, at the rate of 1/3 of the admissible salary cost 2 years after receipt of granting aid, at the rate of 1/3, and at the rate of full admissible salary cost 2 years thereafter. The same 5, 7, 9 years. A post in an aided educational institution belonging to category 2, date of approval,
Even
which
again,
falls
that's also 2 years, 5 years, something like that.
5 years, but here Milord 2 in respect of 2 Milord, which falls any date prior to 1/6/1994 shall receive granting aid at the following rate. After 1/6/94 was a cut-off date again also, Milord. So they will stand on a different footing.
Yes.
No granting aid shall be payable prior to 1/6/94. That is category 2. Then to category 3. So like this, Milord. They are not also coming under this 94 granting aid order. So Milord, why I am showing none of the respondents in the present batch of appeals before your lordship are covered under this 94 granting aid order. I am showing it for the purpose of making us understand that what is the concept of granting aid, what is block grant. So for that purpose, your lordship may at
No,
this
what is
juncture.
meant by block grant?
I am coming to that. That is the question. Right? Because so they now claim that we should also be governed by the 81 pension rules. Notwithstanding the fact that there is no there, they do not belong to the common cadre of employees. Milord, what is common cadre? Your Lordship may kindly turn to section 10C of the Principal Act.
Can we do one,
Yes.
one small, suggestion?
There will are three
Let us
things.
read the order of the learned single judge.
No,
how
I'll
we are
go to that,
structured.
Milord, because the
Then
Well-
what is the flaw? For that purpose, you
No,
can go to the law.
law, Milord, only one thing, that one earlier judgment of Sarat Parida case was decided, Milord, at the notice stage. Even no, Milord, government was not noticed to file a counter. It was at the stage of admission, its judgment has been delivered, even without affording an opportunity to the state at least to put forth its case. Not, Milord, a case might have been dismissed in limine. On the ground of delay, it was dismissed. Under Milord, ultimately, just a minute, please don't interrupt. I don't make submissions out of record. Sarat Parida case, Milord, which was carried in appeal to Supreme Court without filing any writ appeal here, single bench order, was dismissed on the ground of delay. Milord, your Lordship may kindly have the. That is
Single judge's order.
single judge order, Milord, is this. This case, Milord, certain, Milord, questions of law, this is for inquiry, I'll argue now. This Sarat Parida is for inquiry because the provisions of the statute and the governing law which were required to be placed before the Honorable Single Judge have not been placed. So this judgment is for inquirium, dismissal in limine on the ground of delay, Milord, your Lordship knows, does not attract the principle of merger. Punya, Mohammed and Khode distillery, Milord, comes at my rescue. It does not, Milord, end in finality. It has to be, Milord, tested in the touchstone of the statutory.
Now, let us see the single judge's order.
Milord, I passed on that.
Yeah, no.
The earlier Sarat Parida case.
Yes, you have passed on.
Sarat,
Correct. This appears to be a considered order.
no,
Let us
Milord,
see
that's
what are the this order is followed in rest of the matters.
in rest of the matter.
So this, if this goes, rest of the matters.
No,
will
that is
automatic-
not under challenge now, Milord.
It's not
This
challenge.
Sarat, Milord, this Sarat Parida judgment is of 19, is a standalone case.
One more copy you have to
Yes,
give.
this-
The state has to be little gracious to the judges.
No, always, Milord, I do that, I have to-
2015.
No, Lordship, I am more than
Pension-
gracious.
Pension may deny.
No,
Copies you have
no,
to
Your
give.
Lordship is, I am more than conscious while before I have told them categorically make 2 copies of extra for the court, 1 for me. Even if I am not referring to many of them, because I can remember the paragraphs and tell you, Lordship.
Because this
Yes.
judgment, the validity of this judgment is the jugular vein of your case. If this judgment is shown to be per inquiry,
No, I am showing that, Milord,
Therefore-
because that is what.
therefore, that we have to read together. Now, you get copy of here, we'll get it here. Get one xerox
We
of
can
it.
provide you copy.
You have, give that, give it. Take that.
No, read every time. Yes, sir.
Same one. Yes, that you can give back to learned education.
No, Milord,
He has
yes.
marked in that. It may come to your help.
Milord, this Sarat Parida judgment, Milord, Your Lordship, Milord, may I place it?
Yep.
Yes. In this writ petition, the petitioner has prayed for quashing the order dated 3/6/2013 under Annexure 9 passed by the Director, Higher Education, Odisha, Bhubaneswar, with a further prayer to direct the opposite parties to sanction and pay the pensionary benefits to him. The petitioner's case is that while order dated 15/7/1975 of the governing body of Swami Vivekananda Memorial College, Jagatsinghpur, he was appointed as a peon, cycle stand guard, by the governing body by following due process of selection. By the office order dated 25/2/1982, the petitioner was appointed against a substantive post of peon in the pay scale of 200 to so and so. After such appointment, he was directed to work in the college library as library attendant as per order dated 25/2/1982 under Annexure 4. It is the further case of the petitioner that Swami Vivekananda Memorial College, Jagatsinghpur was established in 1962, and while receiving grant in it, it came to the direct payment fold of the government from the year 1974, and as such, it is an aided educational institution within the meaning of Section 3B of Orissa Education Act. It is further stated that as per granting aid principles of the state government for the aided colleges, though the petitioner should have received granting aid after 5 years of appointment, and proposal in that regard was submitted by the college to the government, from time to time, he was not paid regular granting aid. After much persuasion, his appointment was approved by the Director Higher Education Orissa by order dated 6/12/2012 against the post of library attendant from his initial date of joining.
No, it says
Dated-
that there was a direction to consider that representation if he is found to be eligible. Then
Right.
kindly come to para 4.
Para
Say,
4.
This was decided without giving an opportunity to you people. Kindly read first sentence of para.
No, not this. The present batch of appeals, Miller, not Sarath Parida.
So
Whether
Sarath
Sarath Parida facts would be applicable to the present set, Millard, your lordship got the fact. Here, Millard, it is a college
Yeah.
which was established in 62
Yeah.
and was in the fold of granted aid in 1974. He is an appointee of 1982, Millard. Lordship got it, Millard.
Correct.
1982, he was given the sanction scale. Maybe the approval was later, but it was as per the old granting aid principle, not under the block grant. Lordship got it, Millard.
No, we'll understand. like
No,
this.
your lordship may kindly,
No, I have
this
understood.
is very important. Actually also, Millard, the present batch of cases, they stand on a different footing altogether. So state has a right at least to, Millard, rebut the allegations, whether they come within the sweep of Sarath Parida or not. For the sake of, Millard, argument, even if I concede for a moment that this judgment has a binding value. So apart from that, Millard,
One clarification.
Yes.
One clarification. Do you mean to say
yes.
two things? Whether Sharat Parida, Sharat Chandra Parida,
Absolutely, Millard.
does it lay down the law or not?
Sarath Parida case, Millard, is not the same as the present batch of
We'll
petition.
come to that. At least in similar cases.
The Millard, pensionary benefit is being given to the direct payment people. He is a direct payment, direct under the grant in it.
So
So did your lordship mark it?
Understood the point. Whether
It is not denied.
Eh?
Direct payment, teachers are not denied the pensionary benefit.
Two things.
Question is block grant. Here, Millard, Sarath Parida doesn't say that his appointment was under the block grant principle. Lordship got it, Millard. Actually, para 2, Millard, it is very clear and lucid.
No.
So therefore, Millard, Sarath, sorry,
Parida.
I'm
Just,
I'm sorry,
we have to write the judgment.
right,
So you have to convince us
right,
certain things
right,
when we have doubt.
right,
Now we have a doubt.
right.
We are asking you whether Sharat Chandra Parida, does it lay down law or not is the first question. Second one is, if it lays down the law, whether under the shadow of that decision, can they get the relief or not is the second question.
Answer is very simple, Millard, and very straight. Sarath Parida ratio is not applicable to the facts of the present cases.
So first question
Yes.
is answered in the affirmative by your answer to the second question.
No, Rule 3 is there which governs the pensionary benefit. Millard, to which category of employees it would be applicable, Millard, that is also there. Here, Millard, the code goes to interpret that block grant is also direct payment. Because it is not there, expression is not there defined, so therefore it is also direct payment, you grant them pension. Millard, Sarath Parida doesn't say so. Lordship got it. Sarath Parida is an employee.
The answer we got it. First answer we want to know.
First answer, my lord, would be twofold.
Whether
Even-
this laid down the correct position of, it may not be applicable to them.
To them. My lord,
First question.
yes.
Whether this lays down the correct position of law.
My lord,
Or it is a per inquiry.
no, it is per inquiry. Why I am submitting, my lord, I am coming one by one. First of all, the category, the college, in which this, my lord, there are two concepts. The college, the post, and the incumbent. They are all, my lord, different connotations. My lord, aided college is really a very confusing concept to many. At a first blush, they have so many complex issues. It is really very difficult for any common man to understand. Unless even, my lord, most of the secretaries, they have spent 2-3 years, they have not understood what is the exact. It is really confusing. My lord, what Sarath
We
Parida,
understand that because
let's look at it.
Jeremy Bentham said in his famous book,
Right.
Theory of Legislation and Morals,
Right,
where he wrote,
right,
law shows its face in mask.
right.
Law shows the
That's-
face always in mask only.
Correct, correct,
Till mask is, till
Correct.
parda is,
correct.
parda.
So that is why that is your
Same way.
lordship, therefore your lordships are there to interpret, to say what the correct law is. So, my lord, I am on a, your lordship, but from factually also. 82, he came to be appointed.
Correct.
He got the granting aid. Under the granting aid, maybe the approval was done later in 2012 because of maybe multifarious reasons.
This
What
was
is-
challenged.
We challenged
This
it.
judgment was challenged.
It was dismissed on the ground of delay.
Ah.
So the question is, my lord, whether dismissal in limine or on ground of delay can be, my lord, treated as attaining finality to this judgment, applying the principle of merger. Your lordship knows, unless leave is granted, it is converted. My lord,
No, it does
136.
not become judgment of the Supreme Court is true.
That's correct.
But
So
this
therefore-
becomes judgment for the state.
That is correct. So whether Sarath Parida fact can be straightway applied to cases of any aided college employee is the
may not-
larger question.
That may not.
That's correct. Your
That
lordship
may
is
not.
correct.
That requires.
Sarath Parida has already got the relief because it was due to them. Because your lordship, they state, your lordship knows they go to Supreme Court. It's not in every case when they feel that no, something has been, let us go to Supreme Court. I am not on that. But the question is, he was under the direct payment system following the granting aid principle, and the status of the college in which he was serving was in an old college of 1962, my lord. Their employees are quite different. Those batch of employees, my lord, who are before my lords as respondents here, they are, my lord, and other employees working in aided educational institutions of the state who have already completed or will complete 60 years of age on 1st April 1982 will retire from service with effect from the said date as provided under Rule 19 of the Odisha Aided So-and-so Service Recruitment. My lord, a big rule. Your lordship was Rules 1974. It is further clarified that all such employees will retire on or after 1st April shall be entitled to the retirement.
Retirement benefit.
This is the notification your lordship was asking for. Lordship was asking for this notification.
No, even this gives the retirement, entitlement to retirement benefits.
Right. Sorry, my lord?
Even this order
Yes.
dated 23 February 1982
Yes.
by special officer.
My lord, last
Yes.
4 lines, it is further clarified that all such will
employees
retire on or after 1st April 1982
shall
be entitled to the retirement benefit as per the provisions contained in the Retirement Employees Retirement Benefit Rules 1981. Yes,
They are entitled to retirement benefit.
yes.
Which employee this, the GO is?
These employees, my lord, this Rule 3 application of the rules. Rule 3, my lord.
Let us think. The application of the rule.
881.
This is the jugular vein of the case.
That's correct.
These
These rules shall apply
shall
to
apply.
the teaching and non-teaching staff of all recognized non-government colleges, high schools, senior basic schools, and ME schools, which come under the direct
payment
payment
system.
system. My lord, this is the
Right.
interpretation. direct payment system and all non-government primary schools, including Sanskrit tolls, junior basic schools, fully aided by government in education and youth services department, directly or through panchayat samitis constituted under the Odisha Panchayat Samiti Act or notified area councillor municipality constituted under the Odisha Municipal Act 1915, provided that the government may
Let us understand the three. Let us dissect
Yes.
the blocks of section rule 3,
Right.
which are the building blocks.
right. These rules
Shall apply.
shall apply to the teaching and non-teaching staff
Yes.
of all recognized non-government colleges, high schools, senior basic schools,
and
ME schools, which
Which
fall
under the
under
direct
the
payment
direct payment
What
system.
is meant by that?
That is exactly is the question, Milord, which I was trying to explain from the when I started the submission. What is direct payment?
Is it defined anywhere?
No, a definition is not required, Milord. It is not required.
Construe it.
No, yes. Direct payment means, Lord, so this payment of granting aid under the granting aid principle, which was earlier regulated as per executive instructions until 1994, and then by granting aid order of 1994, which since came to be repealed in 2004 when the block grant order was promulgated by the government.
Where is that?
Even 94, yes, the 2004 order. You Lordship will
No,
get.
what is meant by direct payment?
Yes, direct
system?
payment means, Milord, a teacher or any category of employee who directly receives the salary component from the government and a member of the common cadre of employee. Your Lordship may kindly turn to section
The
10C.
second part may not be correct.
No,
First part may be correct. An employee.
let us forget the second part.
Second part may not be
It
relevant.
may not be relevant also for my case.
So,
May not be relevant for my, because the service conditions are also, Milord, when those I was, Milord, submitting, when those class of employees came to be recruited by the governing body, they were not subject to this statutory recruitment rule. They were, Milord, appointed on their own by the
now
respective
let us see
private.
how the learned single judge has understood direct.
No, single judge has not gone into that.
Let us see the.
So the honorable single judge has not gone into that at all, because these are the questions, Milord, which are to be discussed. If you are issuing a mandamus to the state that you grant them pensionary benefit, there's the statutory rule. You have to look into the entire scheme of the act, rules governing their recruitment and service conditions.
That's true.
In
Let us see if the
isolation,
learned single judge has
Milord,
done it.
one single ruled interpretation of Rule 3 is not enough for the purpose, because there are various categories of employees in an aided educational institution. Milord, I am explaining. One is a management appointed employee. They are appointed by the respective governing bodies. After a few years, they apply to the government for approval of their appointment and payment of granting aid. The government pays granting aid as per the entitlement, yardstick, etc., fulfillment of eligibility, etc. So whether someone would be governed by this granting aid principle under the direct payment fold until 2004 when the block grant concept was introduced, or below the direct payment system which was prevalent up to the 74 was introduced because by way of amendment. So therefore, under the when a college becomes, Milord, fully aided or notified as an aided educational institution, this is very important. The governing body does not have any power to make any recruitment of any teaching staff member. It is.
We are not on that.
No, therefore, Milord, they can't claim parity at the, Milord, with the regularly recruit candidates. That's you've got it. So, Milord, the first, Milord, criteria
Let
for
us see
recruitment,
where-
this is,
Alex,
no, Milord,
we
these
have
things
understood.
are to be understood because,
we have understood. Let us go to where according to where the learned single judge has erred. Take us.
yes. So now, this, Milord, Sarath Parida, your lordship saw it.
Yes.
Only they say that
Sure.
this fact is different. the employee was also appointed against a validly created post in an aided college
In
because it was 74, the college was already notified as a fully aided college. It is a 62 established college. His appointment has been approved under the granted principle under the direct payment scheme. So therefore, my lord, Rule 3, my lord, squarely applies to him. Otherwise, even if, my lord, we ignore everything, it is applicable. So, but, my lord, this batch of cases when they were disposed of by a common judgment, 400, 500 cases, even scrutinizing their individual entitlement, whether they do really come within the sweep of Rule 3 or not, my lord, is a miscarriage of justice. The state has a right to be heard.
Let us see six.
How can a law of Milord would be Sarath Parida has said this? So therefore, all those writ petitions are dismissed by a common blanket order that you grant the benefit because Sarath Parida has been dismissed in Supreme Court in limine. That can't be, Milord. I have a right to be heard. State is also a litigant before your lordship. Milord, every fact may be distinguishable, may be different, may be distinct, their nature of appointment, there be not continuance in the job. Everything is subject to scrutiny so far the applicability of the rule is concerned. Because the rule provides there has to be a pensionary benefit to the teachers or the employees under direct payment for. It does not, my lord, automatically by implication applies to a different category of employees which is based upon a reasonable classification and differentiation. Neither it may not breeds discrimination under 16, nor it is inhibited. The state, by the very nature of it, according to the paucity or the availability of the financial resources.
We have one question to you.
Yes,
When it comes to Rule 3, let us read Rule 3 together.
right. May not individual fact, your lordship, I'll come to the impugn judgment.
Let us understand the law. first.
Yes, yes.
Then we can apply the law.
No,
The
your
facts of
lordship is
each
correct,
case.
my lord. It's my bounden duty to, my lord, to go with your lordship.
Let us read.
I'm not, yes,
Rule 3,
yes.
these rules shall apply to the teaching and non-teaching staff.
Yes,
First block.
yes.
Do you agree that there are teachers and non-teachers?
In every institution.
Sorry, my lord?
In every
In every
institution.
institution.
There will be teaching staff, there will be.
Yes, yes, my lord, it is applicable to both teaching.
So on applicability, you have no problem.
No.
Then go to the next point.
Yes,
Of which employees of which school? They say all recognized non-government colleges, ME school, so and so, so and so.
right.
Are they recognized or not?
Unless, my lord, they are recognized, they will not
They-
even
no.
get the block grant.
Therefore, one by one we'll go.
Yes.
So that we'll pin where we differ
That's correct.
here. Therefore, teaching staff, non-teaching staff.
Right.
It is universal in application.
Right.
Number 2, they are the employees of recognized non-government college. There is no issue.
Yes, no issue.
Go to the, so first part, two parts are now satisfied.
Yes,
And all non-government primary schools,
yes.
whether any of them are here, they are not here. Therefore, that.
No, no, my lord, your lordship, we skip something
No.
here.
Which one?
High schools, senior basic schools, ME schools.
But they are not here.
My lord,
They are not here.
you know, the individual case I have not checked whether they are, high schools are there.
Schools are there. High schools are
My
there.
lord, all, yes, ME schools may be there, high schools, colleges, my lord, individual, how many cases have been listed?
Then,
My lord, neither the honorable single judge had any occasion to see whether they are school or college or non-teaching or teaching, nor, my lord, I have to take that pen here before the appellate court. I have to take the pen here that what is the nature of their appointment, who appointed them, how do they come into existence, whether, my lord, this is very important, which we are missing after ME schools, which come under the direct payment system. This is the crux, my lord, of the case. Whether these block grant employees, my lord,
Any judgment which conceptualizes what is direct payment system. These rules have been there since.
so
1981.
this circulars which I pointed out, my lord, they themselves speak.
Show them.
My lord, I showed 74, 83,
No, wait, direct
85.
payment system.
My lord,
This-
Direct payment system means what? In the light of these rules.
my lord, I read out those circulars in the beginning. Those government circulars and also 1994 granting aid order principle, I read out now. Para 10, 11 and 74, your lordship may kindly turn to these three circulars which I handed over initially while I began my submissions.
We're asking you whether the expression direct payment system,
Yes.
is it employed in any of the government orders which you have now read out to us?
This direct payment system has been mentioned here, my lord. That is, your lordship may kindly turn to the 74 circular first. This is, my lord, conspicuously absent in the block grant orders. That is exactly what. My lord, when the lawmakers make a particular rule, they keep something in their mind.
That we have
What is
open
that?
now.
Yes.
Huh.
That's correct. Your lordship, that's so correct. Keeping in mind, the my lord, what is direct payment they meant? They meant this. 81, when the rules, my lord, were formulated, these, my lord, 1974 was in force.
Yes.
What is direct payment, my lord? That subject itself begins with the introduction, direct payment of salary to teachers after completion of 5 years. The full salary cost was paid until 1985, 83, I'm sorry, 83. Thereafter, this graded manner of 1/3, 2/3 full salary came after 5, 7, 9 years. Under the block grant, my lord, it is a fixed portion of 40%, 60% of the salary like this, my lord. It is in a percentum theory, 40% of the salary, 60% of the like this. So they don't, my lord. Yes.
Okay.
Yes.
Direct payment of salary to the teachers.
Right.
What is the seed idea? To my mind, direct payment means it does not go to the account of the college at all.
Yes.
It goes to the account of the employee.
No, my lord, none. Under the system, my lord, it is being the concept of granting aid, my lord, it is paid to the management. They, my lord, reimburse it from the treasury by
That will not
presenting
be
the.
called direct payment.
So therefore, my lord,
This is to
here the is
exclude.
different. Block grant is completely, my lord, is a different concept.
True.
We give something to the governing body, let you allocate, balance you pay. The
That will be
government's
indirect.
liability is to a limited extent. We don't bear everything. Granted, that is the concept, my lord, wherever it is prevalent. Some states,
Can
my
you
lord,
read
yes.
for a moment?
Direct payment,
Let us
my
read.
lord, that this mechanism, how it
Kindly
is,
see it.
yes. I am
Let us read the
directed to
letter of
say,
law.
I am Chair, it is being paid as a sum called granting aid to the respective management, governing body or management. And the governing body, whosoever may be the designated authority, principal or the headmaster, they have been designated as the drawing dispersing. Earlier, the director was the DDO.
Right.
Now, because there are lots of colleges, or the circle inspector was the DDO.
So
in
individual
case
college
of-
principal is become.
has become the DDO. So therefore, there is no question of my lord directly remitting the amount to the salary account of a particular thing. They are being released under a particular head of account, like there is a head of account for the college. For the block grant, there is a different head of account. For the granting aid, my lord, under the higher education, there are two heads of account. Like, my lord, suppose there is a treasury challan. There are different heads of account. Municipality tax head of account is. They create a head of account in the treasury. So money is being given to the management in a particular head of account. Salary is prepared by the college for presentation to the treasury who releases it, not directly to the account of.
It is no more.
That is
one we want to know from you.
Sure.
Yes, my lord.
Is there any direct payment to the account of the employee?
Yes, yes, sir. ठीक है, मुको your lordship
ये
kindly see.
Palpably
Sections-
wrong and false statement. Let them produce
There
in
is a
affidavit.
statutory provision. After the Education Act.
Let them state it in
Yes, yes.
affidavit. I'll produce the
No,
proof
I
right now.
am showing the statute. I am showing the statute. My lord has dealt with that.
Statute.
My
हाँ,
lord,
चलिए,
your lordship,
चलो, statute.
टिके. Section 7C
Yeah,
seven.
Honorable, a statement should not be misleading by a counsel. On facts, you state the correct fact. How it is being paid.
Yes.
Should I make a wrong statement how it is paid?
My lord, your lordship may kindly see
It doesn't go to the salary of any
7C7,
government.
page 138 of the manual.
Does not go to the salary account.
Yes, that is
Making
provided in the
a
statute.
false and incorrect statement.
That is
in the
provided
court.
in the statute.
That is how they have misled every court minute and these orders have been upheld. Let them answer. Let them answer.
There is a provision under the statute
Affidavit.
and it is being directly paid to the employees. It is being directly paid to the employees as per the statutory provision
By whom it is paid?
by the government.
From government treasury to your account?
No.
Yes, yes. In accordance with section
Sir, my wife-
767.
Give your account.
Yes, my lord, we
That is
provide.
absolutely false.
Your lordship may kindly see.
Before coming to the court, this
Your Lordship,
particular aspect, I have verified 10 times, both the secretaries
My
were
Lord-
present in my office in the morning, higher and school. I was checking the special
My
secretary
lord
also.
may kindly see,
Making misleading the
my
court.
lord may kindly see one provision.
No, that we'll see, but
Yes.
Law
get the,
is one thing.
Yes.
No, let him file an affidavit.
Fact is, it is being paid directly to the employees.
get some,
Absolutely false.
Give that account.
Yes, we'll file
No,
an
let
affidavit.
them file an affidavit. But it is not there, Milord. You Lordship may believe me.
They are producing the document.
Salary statement.
Milord, the government is paying, Milord. I have discussed with the secretary how it is being paid. Treasury.
Sir, will your lordship permit me from
He is constitutional functionary.
My lord,
He is making a statement. There is no concept of government check being given to the employee to credit it to his account. That is his version.
Yes,
We do not.
yes.
We are asking you, whether the check is, now the amount is credited to the account of the college. Because under the rules, every college is supposed to maintain an account.
Yes,
There are such rules I have seen in some matters.
yes, in my case,
The
your
government,
lordship has decided.
the government credits that amount to the account of the management institution, saying out of X amount, Y should go as the component of the salary. And Z should go for infrastructure, etc. Just illustration on accountancy.
No, my lord.
Then, whether check is given, the amount from the treasury is credited to the account of the employee.
Account of the employee.
Is our question.
Yes, yes. Account of the employee.
The management or from the treasury of the government to the account.
Account. Account of the employee.
107.
10?
107.
No.
Let's-
no, no,
This is a principal.
no.
Principal.
Read again. What you have produced, you read again. The very statement has come from the college. See, the statement is coming from the college.
It has.
The check has been sent by the college to the bank. How do you say?
Yes, some software and it has been sent. to
And
the-
Oh, that is
principal
not.
of the college,
What is
Milord,
said
is
here
the ex
is the
officio
government
secretary of the
directly
governing
to
body.
the teachers.
Right, Milord, secretary, principal is the ex officio secretary of a college. Governing body has a different president, it's a private body constituted, Milord, approved by the government.
My lord has categorically decided that point.
can your lordship look to this judgment?
But your lordship judgment.
ठीक है then
referring to seven.
Should we continue in this
No, no,
peaceful manner?
just stop it.
Like,
Let them let him complete, sir. Let him complete.
Well,
All
that
other
debate
ones
is
let
no
them
longer
comment.
res integra.
I can.
It has already been decided by you.
Assimilated my thoughts and making submissions.
Take it, given to check.
It's a serious matter, my lord. It has ramifications to the tune of 27,000 crores on
Gotcha.
Exchequer. I am serious.
What you say may not be correct. What he says appears to be correct. From your document. The credit, the check is of the treasury or check is of the management?
This is the software, it's not management.
Huh?
Management, I have got software.
No, you are going to the second page. You are going to first page.
Go to first page.
That's a check in
Or
one sent to the
The copy the lawyer.
treasury and treasury return is giving. Obviously, it has to go to the treasury.
Software is one.
Anchor Lachman.
Yes, this money, the drawing disbursement officer has to send it to the treasury
Right,
only.
everything, every government money has to be paid through the treasury.
It has come.
Ticket road.
They don't know the finance mechanism. I will explain tomorrow, my lord. I have understood, my lord, in the morning.
Ticket road. Kuna gotte minute karte to karte.
Exactly.
ex officio.
And that is how the.
Secretary as governing body.
college.
With your also kind submission, just for a minute.
Secretary and
And you also
confer-
look to this judgment.
Your lordship
I-
judgment.
Your lordship.
Loknath
Yes,
Behra,
yes, yes.
that point has been dealt with.
You have to kindly.
Your
At least
kindly
there should not be an interruption.
Your lordship kindly see paragraph 5.3.
There is no review. That judgment.
No, sir. Sir, kindly.
5.3.
Exactly the lordship to put that question, that is the answer. 5.3. The vehement submission of the Law and AGA that the institution in question having the facility of block grant, take Mr. Choi, please. Facility of block grant, and that the petitioner has not been in the direct payment system is difficult to agree with, and reason for this are not hard to see.
It is not the answer to your lordship's question. It is in common.
Please. 1969 Act has been amended by the Amendment Act 1994, whereby Section 7C has been introduced containing 9 subsections. Subsection 7 has enacted the policy of direct payment system, which become obvious by following text.
That has been quoted.
That they are arguing on merit. If your lordship could,
A governing body or managing committee desirous of having the facility of grant in it shall make an application for the purpose with such period and shall furnish such information and document including audited statement of account of the institution as may be prescribed. It shall furnish with the application and undertaking to the effect that granting it sanction for the purpose or meeting part of all of the salary cost. Yes, sir. It is not the case of the opposite party in that pleading that even after introduction of the new provision, the institution in question is not following the direct payment system. In fact, the petitioner has produced the very order dated 18/6/2020 issued by the Deputy Secretary to the Government, Department of Higher Education, addressed to the principal of our institution, wherein direct payment system is mentioned. Petitioner has been in the pay scale of 9,300 to 34,800 with grade pay of 4,600 by virtue of the approval by government order dated 10/2/2010, followed by the Director of Higher Education order dated 17/2010 and order number 27371 dated 2019, as has been reflected in the pay slip dated 18/6/2020, which also mentioned that the institution is under direct payment scheme. Let the Lord Advocate General complete our arguments, sir. We will give each and every answer. And you also kindly look to the judgment in Sarat Parja case. That is a
that this
case.
is writ appeal is pending against this judgment. My lord, if they want to submit like this in a piece, I am sorry, my lord. This judgment is already appealed against. My lord, your lordship, that is already in appeal. State is in appeal. So, may I only submit one thing? Today, actually, there is another very tender, big matter, is Ajodhya Sagar Setu. Honorable, that may reach
We'll have it tomorrow.
tomorrow 2 p.m. I'll continue.
So one other matter we have put at 2 p.m.
No, any time after that.
We'll send words.
No issue. I am available now for the entire week. So I am
So
available.
where from, and see, your rule maker has employed the terminology, the term.
I'll explain.
Direct payment system.
Milord,
Where from he got-
everything
So-
I have, Milord, prepared myself to answer. Your Lordship is free to put me any question on any issue, law, fact. I am fully equipped. I will answer your Lordship's question. Every issue, Milord. This direct payment I am coming with, Milord, an affidavit tomorrow.
So the jugular vein of the case will be
Yes.
whether it is a case of direct
Payment or
Yes.
not? Yes, that
or
is what
it
I am
is some
saying.
other.
Yes.
That's correct.
And
Whether
to
block
understand-
grant can be, Milord, termed as a direct payment. That's all. That
Therefore,
is
to
the sub question.
understand,
No, Lordship is correct.
that is the question.
That's-
The rest of the things are.
That's correct. That is the
The-
issue because
Your Lordship,
make
rightly
your
put
Lordship.
that question. So far as rightly put that question, so far as that Sarath Parida case is concerned, though that has been referred to, but the Honorable Single Judge in the interim judgment has dealt with each of the provisions, what is under direct payment, whether it has been.
No, that's in the admission stage,
That's-
Milord.
And that
Without delving
Sarath
into
Parida
the
case,
facts.
Your Lordship will find that is. a
400 cases,
That is a
Milord.
question.
And he was
Per
receiving
day,
block grant.
why have they
granted
come?
order up to
Sarath
2009.
Parida, it is a judgment, you grant us the benefit.
And
State
you have
has
to
a right
look to the
also
judgment,
on
interim
facts,
judgment.
Milord. Milord, in appeal also now, we cannot go into facts here. Your Lordship may kindly consider 27,000 crore we are examining.
Yes.
That would be the burden on exchequer. I can't make the state proper and a Milord to put it in debt trap. Your Lordship have also a public duty to see that whether my purse permits. Milord, I'll address tomorrow what? Deeply great.
So only one thing, the Lordship may keep it in mind, Sarath Parida was a case of block grant. He was receiving block grant under the 2008 order,
9 order.
9 order.
Even then pension is paid,
Yes.
Then-
not a case of direct payment.
Another thing you also kindly keep it in mind,
And
all these cases, now they have been brought under the 94 grant rate order because of the non-interference by the Supreme Court. A judgment has been delivered. All these block grant employees who
That
have
is the
already.
subsequent development.
Yes,
That
all.
is the subsequent development. And so far as block grant orders are concerned, those are all statutory orders and those orders have been issued under section 7C of the Orissa Education Act, 7C4. In all the block grant orders, my lord, direct payment system has been mentioned. That
My lord, there is no order in the terminology of your block grant. All orders are, my lord, the granted order. But what they did in 2004 onward, granted in the shape of block grant.
And aided
And they are
education,
now saying it is block grant. And whenever the institution or the institution receiving recognition, they have been notified as aided institution under section 3B. Those who are under even 94 granted order, those who are even under the 2004, 2008, 2009 granted order. All have been notified as aided. institution.
all these institutions are notified under section 3.
And we will produce the past two months, because today is not
Therefore,
available. Tomorrow you will
Girish
bring it,
case,
already-
which has been
already-
upheld. In that case, it has been held that there is no distinction between block grant institutions and full grant institutions.
Yes.
Sir, I have come from Noyagada on the kind order passed 22nd from Honorable DJ Bhakswal Court, Noyagada, sir.
Now we are in the mid of part heard matter. We'll come